Hey everybody, welcome. I am JD Houvener, and you've made it to the Bold Today show. I'm here every week, Wednesday at 9 a.m. Pacific and noon on the East Coast. I'm a patent attorney, and I'm also the owner here at Bold Patents Law Firm. And I'm here to answer any questions you've got about the patent process, intellectual property, trademarks, patents, trade secrets, copyrights. Bring it on. This is a program for you, the inventor, the entrepreneur, the business owner, to bring forward any questions, those burning questions that you've been wondering about, but afraid to, right? And this is a forum to share not confidential inventions, but just process questions like how to get started, what is a patent search, what's a provisional, what's a non-provisional. I love live questions, so I'm going to be taking those as priority. Today we've got an action-packed half-hour plan for you. I've got an agenda here I'll lay out. Before I do that, I want to just put down the legal notice as I usually do for some of our repeat viewers. No, this is this is not a confidential discussion. I'm not your attorney by nature of you joining the broadcast. And just to obviously, let you know, we don't want to have you sharing any confidential information here. If you do want to get started and you feel like you want to take action after sharing, some comments or getting some questions answered today, I'm going to be providing a link for you to schedule a free 20-minute screening session, we call it, with our firm to see if now is the right time, to see if patent law is the right thing for you. So click that link right there. At any point, today or after that, you can speak with one of us and see if we're a good fit for you, and if you're a good fit for us. It's a great way to interview, make sure the timing is right. So thank you for those likes. I appreciate it. Do send those questions in. There's no question too simple. I love this stuff, and this is why I'm here. I believe strongly in informing inventors, making sure you guys know what you're getting into before you get started, before you hire a patent attorney, and that's why I wrote this book. So by taking action and scheduling on that link, we give you a free PDF to the book. And it's a great 150-page tutorial on everything patent law, things you wondered about, things you've heard a lot about online. It's a condensed version that gives you everything you need to know on how to get started. Okay, so today we're going to be talking about claim drafting, patent claims 101. I'm excited to get to that. It's a super patent attorney nerdy subject, and it is super detailed. I've got a lot in store for you, to looking at utility patents, design patents, and plant patents, believe it or not, what the different claim structure looks like. And also hope to get to answer our Avocom question. So if you're from Avo, thanks for joining. I'm going to be getting to the questions rather at the end of the segment. So hang in there for those, okay? All right, so let's start ahead. And I'm going to be checking the scroll here to see if we get any live questions come in. But the topic of the day is patent claims 101. So what is a patent claim and what does it mean? Okay, well, I'll just say the very easiest definition is that is what you own. Okay, if you do all the hard work of the research, applying for a patent application, convincing an examiner at the USPTO that your invention is indeed novel, non-obvious, and has utility, at the end of the day, you get a patent grant, right? And what does that mean? Well, for utility patents, it's the written claims. Okay, it's the numbered claims at the end of the patent that you actually own, and that ownership allows you to exclude, right? It's an exclusionary right. It allows you to prevent anyone else in the US, let's say, potentially other jurisdictions outside the US, from making, using, or selling that invention for up to 20 years, okay? Huge benefit, right? The big incentive to bring inventors out and allow you to share your invention with the world. That's the US government saying, yeah, awesome. Thank you for helping us become all smarter. We're gonna give you this huge reward of up to a 20-year monopoly, and it's yours. Have fun. Profit with it, if you will, monetize it, license it, however you want to share it and reap the benefits of being that inventor and for sharing the knowledge with all of us. On the design patent side, it's not written language, okay? It's actually the drawings, right? The drawings control what you own. So it's the black lines, the shaded lines, the way that it's curved, and it's the article of manufacture. It's a product. It has to be made, it has to be physical in order to be a design patent. So it's the actual shape and ornamental overall touch and feel. That's what you actually own with the design patent. With a plant patent, right, something that grows from Mother Earth, you found a way to, in a scientific lab setting, been able to reproduce consistently, and asexually, right, not requiring bees or pollinators, right, to actually reproduce the plant, genetically modify and grow a unique strain, right, that will grow on its own consistently with unique properties. And so if that plant itself, the structure, and of course what it yields is novel, non-obvious, then you're able to get a plant patent. And the US government will give you the same benefit of up to 20 years of exclusionary rights to prevent anyone else from being able to make, use, or sell that plant variety. Okay, so I've laid out 3 different types of patents and the type of claims, right, and what that means to own. So I want to actually show you what some of those look like. And so with all the hype with respect to crypto and fintech, what's behind that? The technology behind a lot of cryptocurrency is actually blockchain, right? Blockchain, for a lot about that. Some of you are probably in that industry and field and may know more than I do about it. So I'm curious to see if we get any questions on that. So I found this first one here, which is actually owned by a Chinese company, okay? And you probably have heard of Alibaba or Alipay. So Alipay Information Technology out of Xinjiang is the owner, okay? And you can see that right here under category 73, that's the owner of this patent. And the CN means that the country of China. Yu Junpeng is the inventor. And so likely they were an employee, so they assigned it, or maybe they were the inventor solo and they sold the patent rights to Alipay. So the application, abstract, while it is kind of dense, it is just one paragraph. And the invention relates to a smart contract, and not just a smart contract, but where there is consensus. And I think that's important. When you have a contract, you want to confirm that all parties agree, okay? And so there's this notion of this abstract saying that there's a method of having a enhanced security around executing a first smart contract on the blockchain, where it verifies in plurality of nodes, meaning just several nodes, and it's going to confirm that there is consensus among 2 or more consensus nodes. And so it does that using a variety of technology and tools. So that sounds like an extremely broad patent, right? This patent covers the ability for, basically they're going to be able to exclude anyone else from having a contract where there is consensus required. My goodness, that is probably almost every contract out there, right? So it's pretty amazing. Sounds quite broad. But what I want to get to is you can't read the face of a patent, right? You can't just take it on the cover. You can't read, understand a book from its cover. You shouldn't assume the rights based on the cover page of a patent, okay? And even though you may not read patent cover pages too often, it is something that a lot of people and a lot of companies, even those that are pretty well established, sort of get put off by, and like, oh, wow, well, we definitely got to stay away from that technology. We're going to get sued by Alipay. But I want to encourage you to scroll all the way through this, quite lengthy specification and drawings, intimidating, dense language in the written description, and scroll all the way to the bottom. Okay, this is a utility patent, and so the claims, what they actually own, is way at the bottom. Okay, way at the bottom. It starts here on page 30 of 32. The invention claimed is, okay, and you can see number 1. The first independent claim, this is the example I'm using for our lesson today. It's huge. Look at almost an entire page worth, and it's actually 6 separate clauses, okay? And so this claim, meaning that the examiners at the USPTO said, okay, you're claiming these 6 things, and all of these must be, in place. Okay, if you do all of these 6 things, then you're unique, okay? And so generally, the longer the claim language, the smaller in scope the rights are when it comes to utility patent claiming, because they've had to add restrictions, add specificity to the claim language. That means that it's actually a narrower claim, because if a competitor to Alipay just doesn't perform one of these elements, they will not be liable for infringement. Right? In order to prove infringement in court, the owner of a patent would have to prove that every single element of this claim 1 is met in order to get an infringement claim to be successful. So what I did is I broke apart the whole claim into 6 separate segments, and we'll see if we can get through this with the time we have. I'm going to check back and see if I have any questions. Looks like we don't. Thanks for those thumbs up. So let's take it one clause at a time here, okay? And I just researched this morning, and like I said, I don't claim to be a blockchain expert, but let's just cruise through this and see if we can make sense of it. So first clause, okay, a computer implemented method, right? This is almost every software, right? It starts like this, every software patent. Plurality is a fancy term for more than one. process of smart contracts, where each of the plurality of process smart contracts is configured to execute on a first blockchain. Let's just stop right there. If you're a competitor to Alipay and you don't have a process smart contract, right? There's this sort of term of art called, it looks like they've sort of defined this, process smart contracts. That is something you should start looking at right there. Are you even, potentially infringing, or are you dealing with a non-process smart contract? Okay, so I would just start right there and evaluate, hey, is this even in the realm of potentially infringing this patent, or do I indeed actually have a process smart contract? Let's assume that you do have a process smart contract and you have many of them. Okay, so far you're infringing, right? So each process smart contract includes programming codes for implementing a process that includes 2 or more steps. Let's pause again. If your process smart contract only has one step, right? Only one action, one process, you're not infringing, because this requires you to have 2 or more steps. Okay, let's just keep going. I'm just kind of showing you how there's specificity built into every aspect of the claim. At least one of the steps involves determining whether a consensus is reached regarding whether to approve or reject an item. And at least one of the steps involves performing an action based on the determination of whether a consensus is reached. Okay, so again, it's quite specific. Even in this first element, they're actually calling out what the consensus is about. So if the consensus is not about approving or rejecting, the consensus is about some other conversation, or maybe there's a middle ground of maybe, okay, it's arguable that you are not infringing, right? Because you're doing other than approving or rejecting. Those are binary, right? It's a very fixed subject. So there's lots of wiggle room, I should say, when there's a long claim. But let's assume that you're doing these smart contracts, and you are trying to get a yay or nay out of every single one of the nodes. Okay, let's see if you're still infringing. So providing a plurality of consensus smart contracts. All right, well, this is a different term, right? We're not talking about process smart contracts. We're talking about consensus smart contracts. So are you even using consensus smart contracts? Or in each plurality of process smart contracts is configured to execute on a second blockchain. Each consensus smart contract includes programming codes for implementing a process for determining consensus among a plurality of consensus nodes according to one or more consensus rule. Each consensus smart contract includes a public key or a private key of the consensus smart contract is corresponding to the public key is stored in a key management system associated with the second blockchain. Yikes, okay, this is probably throwing out a lot of competitors because you're including these 2 different types of smart contracts. It's relying on this public key versus private key, all right? And the whole key management system. So if there's no keys involved, you're not infringing. If there's no key management system associated, you're not infringing. So I hope you're kind of getting the gist of this conversation, that as we go through these elements, you can kind of appreciate the fact that while it may be intimidating reading the abstract of this patent, the reality is that it's quite specific, and the scope of rights is quite narrow. And this is common, in spaces where there's a lot of innovation in blockchain. Okay, you're going to get these sort of very incremental improvement patents where they're adding value, they're providing knowledge, and they're innovative, but they are quite narrow in scope. And so it needs to be appreciated with respect to how much value they actually are and what impact they can have in the marketplace. So clause 3 goes on to call about having whether it's consensus is reached among a plurality of consensus nodes, and there's multiple process smart contracts. The 4th one looks like there's a digital signature required. The 5th clause requires that there's this validation message has to be sent, right? So if there's no validation message from the consensus smart contract, again, you wouldn't be infringing. So these extra layers, right? Extra specificities further narrow the claim. And the last one says, fairly generic, but it's performing an action on the result of the determination of whether consensus is reached. While that is quite generic, that may be pretty an easy threshold. If you're not in fact performing any action, it's just sitting there, well, then again, you wouldn't be infringing. Okay, so for further reading on patent claim language, specifically for utility patents, I will encourage you to visit this right here. And I'm realizing now, unfortunately, I wasn't sharing my screen. Darn, I really wish I was sharing my screen the whole time. I forgot to do that. I had this whole breakdown here. Man. Well, shoot, sorry everybody. Let me share here briefly. Okay. Yeah, so this was the patent I was looking at. Patent 11,057,221. And this is that abstract we're talking about, where this abstract here, really just can scare a lot of people, right? You can say, oh my gosh, these people have protections over all smart contracts where there's a consensus being sought. And the issue is, it can intimidate and it can sort of seem more valuable and impactful, and that, my goodness, I'm probably infringing this if I use smart contracts. But the reality is, when you scroll all the way down, right past the charts and the flow charts and all the complicated languages, the claims here, way down on page 30, this first claim that we looked at earlier, we talked about, without sharing you, I apologize, is six huge paragraphs long, right? It covers almost the whole page. And so as I shared the breakdown of each of those, for each of these clauses, right? Each of these clauses of that claim further narrows, right? Further knows what it is. So here there's this concept of a process smart contract, and it requires there to be an approval or rejection of an item. The second clause talks about how there's a public key and a private key in this key management system, right? So if you're not using that key management system, you wouldn't be infringing. For the third clause, it talks about having multiple process smart contracts. The fourth and fifth clauses, there's this vote where it has the message requesting a vote. And also then there's a validation message sent. So all these extra steps, they further narrow the scope, and it would likely reduce the likelihood of there being a true direct infringement. For those of you who are interested in looking at patent drafting more, I did submit that link. And sorry I didn't share earlier. So let me just jump back and see if I have any questions. I know I don't see any questions. So use that link to look into patent claim drafting. I do want to show you an example on the design patent side, and I showed kind of a hilarious example, which is it's a design that's a block chain. Okay, I tried to find one that looked like a chain, but they're little blocks here. Okay, it kind of looks like Legos, but they're on a sort of a chain or a strip. But this, is not a utility patent, and so what controls is not this written language of all the references or this description of the figure, right? All these words describing all these different, goodness, there's over 168 figures. So really, they went all out in terms of drawing this design patent. And so you can see none of these words actually control what's owned. What's owned up here, you see this? Claim 1 is right here. Okay, one claim, 40 drawing sheets. So the claim is up here, the ornamental design for a tape forming a toy building block base as shown and described. So I'm calling it a block chain because I was talking about blockchain earlier, but it's a tape, right? And it's formed by a building block base. So these are the drawings. And so what is owned are these solid black lines. Okay, all these drawings here, and they got the broken lines and different views, how they look, the proportions and the shapes, all the different ends, how they could look solid or on the side. But it's not that it has an adhesive back. It's not that it can actually curve or hold force, and that it has fits ergonomically. It's just that it looks this way. It's almost in terms of like an art, right? A piece of art. So if another invention comes around, tries to get a patent on a shape similar or exactly the same as this, they won't be able to get it because this will be owned by the designer, the owner, inventor of this patent. Okay, so that's design patents in a quick nutshell. Plant patents, I wanted to show you this plant patent, very famous for being the first one to have cannabis plant, the Ecuadorian sativa, patented on December 20, 2016. This is a plant patent, and again, you can kind of look at the abstract and get ideas in terms of what it is. But what is owned is at the biological level. So look at the claims for a plant patent. And you have to scroll kind of past these pictures here. The new and distinct cultivar of the cannabis plant as shown and described. So with the plant patent, you get pictures and you get the biological breakdown. And the biological, botanical description is actually part of the claim. So it's shown and described. So it describes the type, form, how it functions, what's actually in the plant, how it grows, what the substance is. And again, this asexual reproduction is required, this cloning of the plant. And it shows each of the steps in order to accomplish that. So, steps 1 through 8, if someone's able to do it using only 7 steps, or sorry, if someone, only uses 7 steps, they would not be infringing on this method, okay? So plant patent is sort of a hybrid between design and utility. All right, let's jump back here. Thanks for being patient with that screen share earlier. And sorry that I missed that. So let's go ahead to answer our Avocom questions. We have a bunch that came in. This one from Atlanta, Georgia. All right. We'll have a good chance of getting my trademark registered, even if the name is similar to another trademark that is dead. There are 2 trademarks that have names similar to mine, but not exactly the same. Also, the one that is closest to mine is already dead. Do I have a good chance of my application being approved? I already used the name on my brand with the TM symbol because I read that doing so can help protect your brand while the application is pending. Good for you. You're way ahead of the game. You're exactly right. If you're using a mark in service or in selling goods, use the TM before you get registration, right? That puts customers on notice, and you can actually use it as evidence when you go through the trademark office to get the application granted, registered, I should say, by demonstrating you're using that. And you intend to use that mark, logo, wordmark for where the source of your goods or services come from. So that's great. And absolutely, if the potentially confusing mark or even exact same mark is dead, right? If the previous owner of that mark abandoned use of that mark in commerce, absolutely, you are able to pick it up and use it for your own commercial purposes. The trademark office, it rewards and incentivizes trademark owners that are actually conducting business, right? They want to make sure customers know the source of the goods and services that they're buying. It's one of the it's one of the reasons for trademark law. So absolutely, I think the chances are very good. And if you have questions about how to get started or how to do that search to confirm that it is indeed novel and to make sure there's no one else out there using it, even though they haven't registered it, use that link above and schedule a free screening session with us to look into that. We also handle trademark work. Okay, let's take a look at maybe 1 or 2 more questions on the trademark side. Okay, this one's out of Richmond, Virginia. All right. Is it trademark infringement to place logo or trademark or writing on someone else's clothing product? I don't want to get in trouble for placing trademark writing on a shirt and selling it by owner. I just want to know that I can make money putting trademark or writing on clothes. Okay, so a couple things here. So it sounds like you're asking if you can place someone else's logo or place your logo or your design on someone else's clothing product. And so there's actually, it sounds like what's actually happening is you're an artist, you're a designer of a certain style or a design, a piece of art. And you want to use that art later, perhaps, as the start of your brand or your label. But you want to put it on, let's just use an example, on a Hanes t-shirt. There is an issue there, right? Because the actual manufacturer, the person that made that shirt is Hanes, okay? You just modified. So the source of that product, right, is selling t-shirts, apparel. That is the classification that you would be seeking protection for. When you have a brand, let's say ABC is what you put on there, okay? And you've got that in a great styling, got cool coloring on it, ABC. And you want to be known for that in the industry. You want to sell t-shirts. If you're trying to become an apparel company, you have to be the manufacturer of the actual apparel in order to get that clarity, right? In order for the consumers to think, oh yeah, ABC, that's who made this shirt. And just because you created that design, that artwork for the letters ABC, that doesn't mean that you're going to have trademark rights for that. Okay, you actually created the artwork for it, and you're the owner of the copyright of that art. So don't confuse copyright with trademarks. If you want to actually be known for and develop a apparel brand, you will need to be the name on the tag, right? The tag name is the person who manufactured the source of those goods. That is the actual owner of that. Okay, so thank you for that question. It's a common misconception. All right, let's take a look at this one. This one's out of Richmond, Virginia, too. That's kind of funny. Maybe it's the same person. All right. Again, it's kind of a T-shirt question here as well. So, can you get a patent to sell T-shirts on the street? I'm struggling with getting rights to my brands. Can you point me in the right direction to make my own brand? Right on. Hey, this happens a lot. A lot of people get confused between patents and trademarks. So you don't need a patent to sell T-shirts in the street. And honestly, you don't even need trademark registration. You just need to make sure that you are that you're either reselling T-shirts or you're not. Make sure you're not using someone else's trademark. Okay, you're not infringing on anyone else's mark to do so. So if you're out there selling, you under your own label, let's use ABC as your brand. And as long as the lettering ABCs doesn't look like or is exactly the same as another apparel company, then you're fine. You're able to start selling that. And as I think the previous question answered, you should put a TM under that ABC apparel company. And that way everyone will know that you will hopefully seek trademark registration and an application for that. And you're claiming that as your brand. That is what customers should think of and know of you in terms of the quality, right? And the actual whole overall service and how you're delivering that through your business. And that's how you develop your actual brand, okay? Patents, of course, are actually for inventions. So if you come up with a brand new type of shirt, if there's utility, right, unique button attachment or way that the collar is able to stand up, or if it's, you got the shoulder pads, something beneficial, some utility to the shirt, maybe zippers in different areas, right, and actually provides a functional benefit, that's potentially patentable. Or if the shirt looks totally different, right, you have a different aesthetic, the actual shape, the button, the figures, the pattern, the stitching is unique, then you get a design patent on the actual shirt or the apparel, okay? Question here, live question, SD, can you patent a language? Well, patent a language, I would say no. If you come up with your own language, and way the actual words of the language would be governed under copyright. If you're the creator of a new art, right, or a way of the actual words themselves and how people understand them, that would be the domain of copyright, okay? Now, my mind is going because I think there could be ways it could be patentable. If you've developed a method of teaching the language, right? Or a method of communicating that language. Let's just use some very interesting, maybe you've come up with a new a new sign language, right? Different ways you move your fingers, or ways of looking in different directions. Okay, I'm just kind of going off the wall a little bit. That method of communicating, a process, a series of steps, that could be patentable, right? That method of teaching and the method of communicating and developing a whole system is potentially patentable, okay? But the heart of the language itself, the actual words and the way it's spoken, that would be governed under copyright, right? You're creating new words or new sounds. But great question. Thank you for that. I love it. We're going to wrap up in just a minute, so please send in those live questions if you have any. Again, I'm going to send out that link again for those that missed it. If you're ready to kind of consider whether you want to move forward with your patent or trademark rights, you can set up a free, kind of low barrier conversation with one of our advisors to see if patents or trademarks are right for you, if our firm is a good fit for you or not, and we'll send you down the right direction to help you talk with an attorney if now is the time. And if you have questions for me, confidential questions that you weren't able to ask in this meeting here, this broadcast, I should say, I encourage you to reach out to me directly. I'll give you my email and my text-only phone number. So please send that over. Again, any questions at all you want to talk about, maybe becoming a client or just want to be a referral partner, curious about how you might be able to get on the show, anything like that. Love to hear from you. So SD, thanks for your live question, and I thank you for those live viewers out there. Please like us, share this on your social platforms. I'm going to be here every week, every Wednesday at 9 a.m. Pacific and 12 noon on the East Coast. Take care, everybody. Go big, go bold.